My name is Jadina Ingastav Esquire, but you can call me Attorney J. And I'm here to answer questions about the estate or lack thereof for Stephen Boss, who we know as tWitch. A lot of us learned to love him either through his DJing on the Ellen Show, on So You Think You Can Dance, or his Instagram, so his social media where he's dancing with his wife, mother, everyone, and just that joyful spirit. And we do say rest in peace and comfort for his family who is still grieving and trying to make sense of it all. But the questions that we have is what happens, one, if he does have an estate plan already in place, and what happens if he does not have an estate plan. Basically, if he does have an estate plan, let's start there. So let's just, since it hasn't come out yet that he didn't have a will or something, let's just start at the point of if he did have an estate plan. Some of the first questions that we always answer is, one, what state did the person live in? He lived in California. Who are the beneficiaries? The beneficiaries, as we know now, or if he has an estate plan, they would be beneficiaries. If he doesn't, then they would just be his heirs at law. We know that he was married. We know that he had 2 biological children with his wife. And we also know that he adopted his wife's child. Okay. We also know that he had his mother and extended family as well. So for estate planning purposes and also non-estate planning purposes, let's just stop there. So spouse, children, parent. Now, if he had an estate plan, what does that look like? What type of plan will make a difference on what happens? So if he had a will, what would happen with a will? If he had a will, the will would allow him to state who he has as his beneficiaries, because you can say you don't want someone or you do want someone, right? Because we're not going by the law right now. We're going by his own decisions. So who does he want to receive what he has? Also, it is going to state how they receive it and designate who is going to be the person that represents him as well, that represents his estate. Okay. It also has in there all of the things that he have. So it should list everything, right? So any contracts, bank accounts, investments, property, anything, it should list all of those things in there as well. It should list any significant things that he had and he wants to give to someone. So any special gifts or, a trophy, an award that he had and he wanted to give to this person, it would list those things as well. And that's what it would have. So he signs it, witnesses sign it, it's good. So let's say that it's good, it's a perfect will. That means we know what he had, we know who he wants to leave it to, we know how he wants to leave it, okay? Now from there, what does the person he listed in his will as an executor have to do? That person will now have to take the will. They have to file it in court. That's called probate. They're going to file it with the probate court, asking the probate court to do exactly what he said in the will. With that, they will most likely not have to pay a bond, because in your will, you usually put that the person you select should not have to pay a bond, right? Because you don't get that back. Also, with that, once it's filed in court, some of the fees they will have to pay the court filing fee. They will have to pay an attorney, because there's very tiny estates. That's the only one you most likely don't need an attorney. However, once it's beyond a certain point, you are going to need an attorney representation. That breakdown is within statute in California law. So how much they get paid, what they get paid is in there, but they will get paid. Okay, so that's another fee in that process as well. If it's not just straight out cash, and let's say it's paintings or anything that's not straight out cash where you know the value, most likely you're going to have to get professional appraisers. They will determine the value of whatever he left remaining. Unless he had insurance on it, then usually it's going to be at that last place with insurance. That's going to be another fee that has to be paid. From there, once all paperwork is done, the court approves the will. The court approves the process by which the attorney and the estate has to take to prove that this is his will and this is how it's going to get done. The final order is done, and the final order lists everything he had. It lists who's going to get it, and how much they're going to get, okay? And from there, you're basically done with the will process, okay? But what are some of the things with that? It is filed in court, so there are those fees that I discussed. It is public because it's filed in court. So that's another thing as well. Do you want everyone to know how much you receive? Do you want them to know what your family have? You don't really want that. Some people don't want it because, one, if you have younger individuals that's receiving directly, you don't want people to prey on them, right? Also, you don't want people to harass them. You know, you don't want them to use it the wrong way either. But outside of that, you just don't want that information to be out there, right? Okay, so that's the will process. That's why I say a will is not enough. A lot of people, it's up for debate, but a will is not enough because, one, it does not save you the time. It does not save your individuals, so the beneficiaries or heirs. It does not allow them access to everything immediately. So there's that delay. So obviously I'm not telling you all the time that it takes, but once it gets to court, like I said, the court has to approve everything. So that's going to be some time. Okay. But you said it, it was what you wanted. If that's what he did, he would go the will process. What's the difference with an estate plan if he had a trust? If he had a trust includes a pour over will. But the difference with just a general will versus having it in a trust, a pour over will is only if he missed something. So it is filed with the court, but you leave it there, right? If there's anything that he has that comes that needs to be probated, then it's very limited. It's probably a very small amount. You may or may not need an attorney, and you do not have all of the additional fees. And with the trust, you're literally listing everything that you have as well. And you're saying how you want those things to go out. He's saying who he wants it to go to, when they receive it, how they receive it, and his trustee. So where it was an executor in his will, if he had a trust, then his trustee has the powers that he had. The trustee does not need court approval in order to start giving out whatever assets he left. The trustee is not limited by what it is that the court would say, because why? It's private. No one knows what's in there. No one knows who gets what, how much they get. And you're able with the trust to be able to select who your guardians are. You are allowing for distributions over time. You have less fees because you're not paying these court fees. So it's a lot more protection. It does not have a delay, and it also have a safeguard in there. So let's say you do have either minors or young adults, right, that are going to have access to the money directly. You can put in there each stage of their lives, what they get outright. You also can put conditions in there, which he may have done or he may not have done, putting in there, if, my wife is not here, because he would have made the trust for him and his wife, saying that his wife gets whatever he lists in there and all of the things she's entitled to by law. But then he may say, if my wife is no longer here and these assets are still available for my children, I want my children to see a financial planner before they have access to this amount of money. I want my children to do this, to do that. And what it does is you're protecting them from themselves, because I'm assuming he has a lot of money that's going to sit there, and that's probably going to grow. Maybe there's investments, there's life insurance policies. If it's in a trust, it gives him the ability to invest that money, right? So a trust is very powerful if that's the tool that he used. Now, let's say he did not have a trust. So he did not make those designations of what he had, who he wants to receive it, who he wants to be his trustee, and the time in which they receive what he leaves. Then that means he had no estate plan and it has to go through probate. The thing with that is where he would have said specifically how he wanted his wife, the children, including his adopted child, to receive the way he wanted his mother to receive. Now, if he had no plan, the state is going to use its laws to determine how everyone receive it and who receives what. So being married and having the children, that already covers the first two levels. There's nothing that probably would be remaining for his mother. That's probably not what he wanted, right? If he didn't have an estate plan. Another thing, big question mark, is what about the adopted child? Now, if he officially adopted her, not just stating that, that's my child, and, sometimes news reports are not right, but if he officially adopts her in court, she will be treated as one of his children. So she won't be like a stepchild. It's not a stepchild. It is as if you adopt that person and they become your biological child. That's how they're treated by the law. So even when people adopt adults, some people, you may have the question, why do people adopt adults? You adopt adults so that they can take as if they're your own. And then there's a lot of other reasons why, but that's just one of them, right? So now they will have to pay a bond if there's no estate plan to the courts. They will have to still pay attorney's fees, the appraisers, and everything else that I discussed about it going to court when you have to probate. But it just adds more. It adds that bond amount. It also adds the fact of who gets what in priority. So there's his wife. So if she's sharing with the children, she doesn't get less than 1/3 if it's her and the children. If it stops at the children, his mother's cut off. If they allow his mother to get, which most likely is not going to happen, the fact that he's married and there's children, you're not going to skip over the children, because remember, the way the law see it is if a child is not provided for, that means we have to provide for them. So that's why it stops there when you do have children and they collect what you left for them. So it would be the wife and the children that's collecting. And I doubt he did not want to provide for his mother. We know his grandfather had just celebrated a birthday the month that he passed away in December. Probably left something for his grandfather. Because with children too, remember in a estate plan, if you did have a trust, you can even state that, I want for the trust to pay their educational expenses, pay their housing wherever they are up until this stage. He may have had in his trust the same thing for his grandfather, that wherever my grandfather is, his housing is paid, his medications are paid, same thing for his mother. So with an estate plan, he would have been able to make so much decisions, not only in life, but also in his passing. So that's what the breakdown is. If he had an estate plan, if he did not have an estate plan, his adopted daughter, if it was officially done in court by order, would receive just how his children would receive his biological children, and his wife will share with the children because California law allows. However, she can get no less than 1/3 of the estate, and that's only if there was no estate plan and it's a full probate estate. Okay, so I'm Jadina N. Gustav Esquire. You can call me Attorney J. Check out more videos on our YouTube page, subscribe, like, and also follow us on social. My information is below. Information is also all over the World Wide Web. All right. Hope to see you again.